Today at 3 p.m., all counties are supposed to have their machine recounts finished and submitted to the State Division of Elections. Regardless of this new court ruling, supervisors are required to turn in those numbers. Here now is what Judge Mark Walker, the Chief U.S. District Judge in Tallahassee, ruled overnight. He said voters with mismatched signatures on provisional and mail-in ballots can cure or fix them. They have until a new deadline, Saturday, November 17th at 5 p.m., to sign an affidavit and provide identification to prove they are a lawfully registered voter. He stressed that canvassing boards are not ordered to count every mismatched vote sight unseen. Now, this decision came after testimony lasting 5 hours yesterday on one of the 7 cases before the court in the Northern District. This was in a case in which Democratic U.S. Senator Bill Nelson was suing the Secretary of State to allow voters with mismatched signatures on the envelopes containing vote by mail and provisional ballots to be corrected and counted. This is a win for Nelson, though attorneys for the National Republican Senatorial Committee on behalf of Republican Governor Rick Scott have already filed an appeal. Orange County's election supervisor is already preparing for state orders to allow voters to fix their mismatched votes.
We are reviewing our emails, we're reviewing our faxes and all of people who submitted their cure for a mismatched signature after 5 p.m. deadline on Monday, November 5th.
Judge Walker stated this in his order: Florida's statutory scheme as it relates to curing mismatched signature ballots has been applied unconstitutionally. Supervisors of elections are directed to allow those voters who should have had an opportunity to cure their ballots in the first place to cure their vote by mail and provisional ballots now before the second official results are fully counted. Judge Walker also showed some anger yesterday, saying Florida has been the laughingstock of the world election after election, and we choose not to fix this. And here we go again. There's another hearing in that same court in less than an hour on another Nelson challenge of the law that says mail-in ballots must be into elections offices by 7 o'clock on Election Day. Nelson argues that a postmark of Election Day, November 6th, should be good enough to count.